So the petition for review is basically asking the Superior Court to review what the administrative judge had denied, which was all my right to due process and evidence and all of the misconduct that APS had committed, which also included failure to investigate, failure to interview the alleged victim, failure to, they fraudulently misrepresented him as being incapacitated when he wasn't. And they allowed these two people, his parents, who were not guardians or anything, to, like, they gave them all the information like they were his guardians or something when they weren't. So while this is all going on, my friend is still there. To this day, he's still there as far as I know. I mean, I don't have any information about him because there's a protection order still. But I can only assume that he's still there, because if he wasn't, he'd probably demand that the protection order be ended. And so I'm sure he's still there. And also because everybody's fighting so hard to keep him there, very clearly. So in the Superior Court, a series of events happened that were totally illegal. First of all, the department, which is APS, but it's now it's the full-on Department of Social and Health Services that I'm up against, not just APS. They came in and said that I didn't have a right to appeal to review because I had to go to the actual merit hearing first. I had to go and they had to try to prove that I had done it. And then I could only appeal that order. I can't appeal for like my rights, which is not true. The RCW, which is 34.05.566, I think it's part 3, sections A, B, and C. Yes, I have almost all the laws memorized at this point. States that you don't have to exhaust your remedy and go to a merit hearing if you have an exception. An exception would be like you can't have a fair hearing because something has happened. And in this case, it has. You can't accuse somebody of robbery. You can't accuse someone of abuse. You can't accuse someone of something like that and not say what they did so they can prepare a meaningful defense. That is due process of the 14th Amendment. It can't happen. During this time, they also gave his abusers a copy of that finding, and they published it in a court publicly, saying, look, she's an abuser. They destroyed my life. I can never work in my field again, in that field as an advocate. I can never work as a teacher again. They've destroyed my life permanently at this point, no matter what happens, even when I prove my innocence. And so while that's all happening in court, the department argues that I didn't have a right to appeal anything and that the court doesn't have jurisdiction. So the court says, yeah, you're right. You're the Department of Social and Health Services. You're right. And dismisses my petition, says he doesn't have jurisdiction. But there's a rule. You can't say that you don't have jurisdiction and then prevent someone from coming back later. If he says, I don't have jurisdiction to rule on your case, that means I come back later. Okay, you're telling me I have to go do the merit hearing? Okay, I'll go do that and come back. But he dismissed with prejudice, saying that I can't come back later and seek review. They tried to shut me down entirely. Why is the Superior Court doing things like that? Is this starting to add up to anybody else? Is this starting to look a little bit like asymmetrical to anybody else? So let's put a pause on the APS thing because there's a whole nother case going on that is going to blow your fucking mind. There's 2 other cases. First of all, the protection order. That came up for renewal again. And by this time, his abusers had gotten guardianship by fraudulently misrepresenting him as being in a vegetative state. I went to that hearing and I said, hey, they committed fraud. They weren't guardians. They couldn't represent him in court. He didn't want to have the protection order. I never did anything wrong. I just showed everything to the commissioner. I said, this is hogwash. I said, they lied on the petition for the protection order, saying they were guardians when they didn't. That's fraud on the court. And they never alleged any statutory grounds. They never said that I hurt anybody. They said I didn't get their permission to do something. I don't need to get their permission to do fucking anything. That's not what protection orders are for. Protection orders are for people who are dangerous. You can't just say, I don't like that you reported my abuse, and so now you can never see the people I don't want you to see. And that's when APS decided to file into this private civil matter a statement saying that I was lying. They had never been investigating these abusers. There was no open investigation from my reports that I had been talking to them for a year about. That didn't exist, they said. They said that they were afraid that I was a danger to him. They said that they were calling law enforcement to let them know that I probably violated the protection order, even though I'd been in fucking Guatemala and Peru. They did all that to cover their asses because of what they did in the administrative hearing, I guess. And the commissioner renewed the protection order. So that's when I filed for judicial review. The judge rubber stamped saying he's not going to overturn it, and I filed notice of appeal, and it went to the Court of Appeals. That case is already in, briefing is done. I filed my 5,000 word brief proving that they had committed fraud, that they had violated all the statutes, that the court didn't have statutory authority to even rule on it, because a court has to have statutory authority. Okay, so like a court can't just decide to rule on things that there's no law about. If the law says that you have to if the law says that you have to be a danger to someone in order to restrain your rights, then someone has to say that you were a danger. And in this case, I had the transcripts from the hearings where his parents were saying, well, no, she's not a danger. She's not dangerous. She never hurt him. She took good care of him. We just don't like her. She didn't get our permission to drive him somewhere. That's not statutory grounds. The court didn't have authority to grant that order. And they lied about being guardians to the court. That's fraud on the court. That means they lied, they committed fraud to the court to manipulate the court into doing what they wanted. And they renewed it without having statutory authority, because the statute, RCW 7.105.450 says, or 405, says that only the petitioner or the protected person can renew the order. And neither one of them were that. So I filed my brief and their attorney filed theirs, and we battled that out, and now we're waiting on a ruling on that. And while that was finishing up, the guardianship review was coming up. And so I filed all my evidence into the guardianship case of abuse by the guardians. And that's the next video, because you won't believe what the court did.